Okay, ladies and gentlemen, we are going to start our event. So please have a seat and make yourself comfortable. Thank you. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, salam kebajikan for all of us. Now, good morning, ladies and gentlemen. Good morning, everyone. I would like to welcome you all back to the summer course of Lex Proficia 2021 that are conducted by the Faculty of Law, Universitas Diponegoro, to the Honorable Professor Dr. Zinatul Ashikin Zainal LLB LLM from University Kebangsaan Malaysia as the speaker for today's session. And to the Honorable Mr. Pulung Widi Hari Hananto SHMH as the moderator for today's session. And of course, to all the fellow participants. Now, thank you so much for all of you for, again, your enthusiasm in welcoming and joining this session for today. So I am Danis Naila Sakina, and you can call me Danis, and I will be acting as the master of ceremony for today's session. And then first of all, I would like to give our praise to our God for his blessing and his grace. So we can gather in this virtual meeting today in this lovely morning. Let us start today by praying so this event will run smoothly without any obstacle. Now, pray begin. Amen. All right, thank you everyone. Now we are going to proceed to the next agenda. It is, again, the most awaited session. Everything is the most awaited session here. So I would like to welcome our special guest, Professor Dr. Zainal Ashikin Zainal LLB LLM. Then today we are going to talk about a very interesting topic that will be guided by our moderator, Mr. Pulung Widi Hari Hananto. Now, without further ado, Mr. Pulung, the time is yours.
Okay, thank you very much, Danis, as a master of ceremony. Good morning, ladies and gentlemen, and also the participant of the Lex Proficia 2021. And first of all, good morning to Prof. Zinatul, and good morning to all of you in here. Good morning from Indonesia, and maybe it's a good day in Australia, yeah? Okay, so I think this is my, before I start the function, I would like to introduce myself. My name is Pulung Widi Hari Hananto, and I'm an international law lecturer in here in Department International of Law. And I think for this session, yeah, it is my honor and also privilege to be the moderator today in the day 4 for the Lex Proficia 2021. Before I giving the floor to the Professor Dr. Zinatul, so I would like to read the CV briefly regarding about the CV of the Professor Zinatul today. So our speaker today is Professor Dr. Zinatul Ashikin Zainal. And currently, she's a professor of intellectual property right and also the former dean of the National University of Malaysia. The expertise of Professor Zinatul, especially in the IP law and about the education background. In bachelor degree, she had bachelor degree in International Islamic University Malaysia, and now she got and also followed by the Master of Law. She got the Master of Law in London of the School of Economic or LSE, University of London, and a PhD, Doctor of the Philosophy in International Islamic University of Malaysia. Now, without any further ado and interruption, I will giving the floor from Prof. Zinatul. More or less is 45 minutes or until 1 hour to deliver the presentation in regarding about the intellectual property law. Time is yours, Prof.
Thank you very much, Mr. Pulung and Ms. Dania. Will you be sharing the slides or can I share the slides?
Yeah, you can share by yourself or also we can also share by committee. So which better?
I will try to share first. All right. Can you see my slides?
Yes, confirm.
How come it's not working? All right, okay. Assalamualaikum, a very good morning. Alhamdulillah, praise and thanks to Allah for His countless blessing. He has bestowed upon us. Blessing and salutations to the Prophet Muhammad, his wives, his family, companions, and all those that follow his teaching to the day of judgment. La ilaha illa anta subhanaka inni kuntu minaz zalimin. First of all, I would like to thank the Dean of the Diponegoro University Faculty of Law, Professor Dr. Retno Saraswati, for her kind invitation for me to join this virtual summer school. I'm very happy to my own student actually. Mr. Pulong did his master's at UKM some time ago, and we are very proud of Mr. Pulong. In fact, we have several alumni of UKM at Diponegoro University. So UKM and Diponegoro, we are very close brothers and sisters. So we're very happy to be part of this virtual summer school. For today's presentation, we will be sharing a little bit about the international IP law, especially in terms of trademark, 3D printing, and domain names. Now, first of all, before we go further, okay, I'm sure intellectual property is nothing new to most of us. IP are creations of the mind. It is both fascinating and challenging. IP consisting of a patent, trademark, copyright, industrial design, trade secret, and GI are all around us. So I believe that IP is nothing new to us. We are using IP, and to me, IP is both fascinating and also challenging. IP is fascinating because whether we realize it or not, we are using IP, we are users of IP, and also IP is all around us. Today that we are using this virtual online summer school, we are using, there are a lot of IP involved, patent, and of course copyright in form of sounds recording, books. And every day when we wake up, the first thing that we do, I suppose most of us when we wake up, the first thing that we do is that we will look at our handphone. So our handphone consists of trademarks, patent, copyright, industrial design. We also use lots of IP because we text a lot, we draw a lot, we make a video and blogs a lot. So all those forms of IP. So in other words, we are inventors and authors of IP, whether we realize it or not. So one thing that I do in my IP class is I do a lot of IP journaling. IP journaling is that if I see that there are a few students from UKM here also. So if those students have taken IP class before, they would know that in my IP class, students are required to do IP journaling. In a sense that every day, not every day, they will have to do entries of what they do every day that relates to IP. So one way to do this, the reason is for them to build respect for IP. So I believe that IP generally encourages ourselves, also our students, to have respect for IP. Now, on the other hand, IP could also be very challenging because IP is and has been international in scope and nature. Because IP law is guided by multiple international treaties, most notably would be the Berne Convention, Paris Convention, also the TRIPS Agreement. On the other hand, even though IP is international in scope, the protection is territorial. This means that IP registered in Malaysia would only be protected in Malaysia. The same trademark or patent would not be protected in Indonesia or Australia or Singapore unless it is equally be registered in those countries. So this is quite challenging because innovators or owners of IP or creators of IP would have to know the international law and also the domestic law of countries where they would want to do their business. Because if the IP is not protected in those territories, so they are not protected. So which means that it could be susceptible to infringement or counterfeiting by other people. Now, the things that we are going to look today is the technological challenges, innovation challenges IP law. There are many instances because of the internet, the 4IR, traditional principles of IP law are not able to keep track with the challenges in technology. Now, for today's discussion, even though IP consists of multiple things like trademark, patent, design, or GI, but we'll only focus on trademark. Trademark, in doing that, we're looking at the main players in international IP, the trademark basics, trademark and 3D printing, also trademark and domain names. Okay, students of IP would know that the main body for IP would be WIPO, which is a UN body. And those students are taking international law will also know that another main player in IP is the WTO. Both are situated in Geneva, and I've had the privilege to do a 2-week training there back in 2014. That is BC, before COVID lah. Now, apart from WIPO and WTO, you would also like to know that IP is also relevant to various other international treaties under UN. That would be the UPOV for food and plant varieties, FAO for food security, WHO for health. There are many issues regarding health, especially in the COVID areas now. Customs, World Customs Organization for enforcement issues, ITU for telco issues. So in other words, IP are not the treaties, the body relevant for IP internationally are not just WIPO or WTO. You should be aware that there are at least 8 other international UN bodies that are relevant to IP. Now, IP, there's also a CBD. CBD is not under is CBD for sovereign state of states, especially for traditional knowledge, biological diversity. UNFCCC for climate change, UNCTAD for trade and development, UNIDO for poverty reduction, UNESCO for intangible cultural heritage, and last but not least is ICANN. ICANN is not a UN body, but it's very relevant when we discuss about domain names and trademarks. Now, for trademarks, at WIPO itself, there are 8 trademark-related treaties at WIPO. The main one would be the Paris Convention and also the Madrid system. Now, apart from the 8 related treaties, there are also 3 joint recommendations and SCT. Now, if I can just mention, I hope I can remember them all. The 8 treaties related to trademark is Paris Convention, the NICE classification, the Nairobi Treaty, the Singapore Treaty, the Trademark Law Treaty, and also the Madrid Protocol and Madrid Agreement. If I miss anything, Mr. Pulong, please add in, yeah? Okay. Joint recommendations, there are 3 at the moment. So these joint recommendations, they are not the level of treaties, but they are useful, whereby member states discuss response to trends related to international trademark law. At the moment, there are only 3. The first one is protection on well-known trademarks back in 1999. The second one, joint recommendation related to trademark license in 2000. And the third one is the joint recommendation on trademark and science on the internet in 2001. So the joint recommendation, there are 3, 1999, 2000, and also 2001. So that means that for the past 10 years, there has not been any addition of joint recommendation by WIPO. I'm not really sure why, but probably the SCT now is the most active committee at WIPO that discusses trademark issues. So SCT is a forum for member countries to discuss policy and legal issues relating to international trademark law. And the most current issues were held in hybrid in May 2021, the 44th sessions. So if I remember correctly, SCT is being held every year, where member countries can bring proposals to WIPO through their respective IP office. Malaysia would be MIPO, Indonesia would be Jan Haki, where our IP office would bring the recommendation or paper to the WIPO committee. So at this SCT, issues of trademark, industrial design, GI are all discussed together. If anyone would be interested to go look into this further, I would recommend you to go into WIPO webpage where you can download all the documents related to SCT. It's very interesting, but it's also a very bulky document to read. Now, the most important treaty for trademark would be the Paris Convention. The Paris Convention applies to industrial property, not just trademark. It's also applicable for patent, trademark, design, utility model, GI, and also unfair competition. But for our purpose, we only focus on trademark only. So there are three main principles. First is national treatment. National treatment means that a contracting state must grant the same protection to nationals of other countries as if they are their own countries. So to give an example, Malaysia will have to give the same protection to Indonesian nationals who register their trademark in Malaysia. They cannot be double standard of protection. Right of priority, this means that if a trademark is registered in Malaysia today, in 29 July 2021, okay, the registrant, the trademark registrar, the trademark applicant would have 6 months to apply to any other member state for registration. So he can apply to Indonesia next month and apply to Singapore in 5 months' time and apply to Australia or Vietnam within these 6 months. And the filing date of those applications will be taken as if the day of the filing in Malaysia. So the first date that is applied in a home country is relevant, is become the filing date of any other application, so long as they are done within 6 months. So this is something very good for trademark owners. Now, however, the Paris Convention does not regulate filing and registration because the filing and registrations are the prerogative of domestic countries and domestic trademark law. Now, under the Paris Convention, that would mean that a person who wants to protect their trademark in multiple countries would have to apply trademark registration in each and every single country. They will have to apply one in Malaysia, in Indonesia, in Singapore, in Thailand, in Vietnam, in India separately. And if they file the application within 6 months, so the filing date would be the first date of the first filing application that they filed in Malaysia. That would be today lah, that's just an example. Now, that would be quite troublesome and bulky for an applicant to keep track of all the filing dates, and also sometimes they also need issues of translation in the national language, because even apply to China, they have to translate into Mandarin. To Vietnam, have to translate into Vietnamese. Now, to take care of that problem, at WIPO, there's also Madrid system. Madrid system for registration of international trademark. So Madrid system consists of two important treaty, which is the Madrid Agreement and also the Madrid Protocol. So both system and protocol of Madrid becomes the Madrid system. Now, the interesting thing about this Madrid system is that an applicant do not now have any country that adopt the Madrid system. There is no need for a national of that country to apply separately in multiple countries. There's no need to apply to Singapore separately or China or US separately. What can be done now is just apply to the IP office, which is MIPO in Malaysia, and then MIPO using under the Madrid system can designate the registration to any country that the applicant identified. So it is cost effective and also user friendly, and also pay only a single fee. So both Malaysia and Indonesia are members of Madrid system. And I would like to congratulate Indonesia, because Indonesia is very advanced in trademark and IP actually. Malaysia just ratified Madrid last year, whereas Indonesia ratified Madrid, I think, 2 years ago. Yeah. And The other treaties that we talk about trademark would be the Singapore Treaty. Singapore Treaty and also the Trademark Law Treaty. So Trademark Law Treaty talks about the standardization of filing of national and regional trademark registration. And again, for Trademark Law Treaty, Indonesia is a member, but not Malaysia. For the Singapore Law Treaty, Indonesia again, both Malaysia and Indonesia are not a member. So Indonesia is just a member of the Trademark Law Treaty, but Malaysia is not a member of both TLT, Trademark Treaty, and also the Singapore Law Treaty. Another treaty for trademark is the Nairobi Treaty. Nairobi Treaty is just about the protection of the Olympic symbol. And again, Indonesia is a member, but not Malaysia. So I think that in this area, Indonesia is very advanced than Malaysia in ratifying the treaties. Okay, we will now go into the basics of trademark, even though I believe that most of us are very familiar about trademark, but just for the sake of refreshing our knowledge, let's go a bit on the basics of trademark. Now, trademark are symbol of business identity, it builds reputation of brands, and provide exclusive rights to the trademark owner. This is a quotation from Forbes magazine in September 2020. Now, trademark in a way defines our identity, because if a person, if Mr. Pulong brings iPhone and I'm using just a Vivo phone, then of course the identity it makes identity of a person lah. And the handbag of Birkin also, and handbag of I cannot read the handbag identity of a lady bringing the handbag. Okay, in Malaysia, Indonesia, I think would be the same situation. Also, Singapore also, Nestle and Milo is a household trademark for household trademark for most of us. When I was a little kid, Milo, we always drink Milo every day, and even today, we are familiar with Milo, Nesvita, or Kit Kat. So for Malaysia, Indonesian alike, so the story of Milo or Nestle is very familiar to us. And you can also see that Nestle has multiple trademarks. It started with a picture of just a bird and a nest, and it has changed over the years. But interestingly, Nestle kept some of their trademarks to be valid, because trademark, as you know, lasts forever as long as it is renewed every 10 years. Now, in terms of Global Brand Awards, you can see that Malaysia and Indonesia have Maggi and Indomie. Indomie is an Indonesian brand, but Maggi actually is a Nestle brand. So we get ourselves in the Global Brand Awards. Now, for the Forbes Best Brands 2020, you can see that Apple, Google, Microsoft, Amazon, Facebook, and none from our side of the globe. Now, what are the function and specification of trademarks? Okay, trademarks are signs capable of being represented graphically, and it must be capable of distinguishing goods or services from those of one another. So this means that, for instance, if we talk about instant noodle, the instant noodle of Indomie and Maggi are different, because each trademark indicates the origin of the product and also the quality of the product. So the functions of trademark, basically there are two main functions: origin and also quality. Okay, in the quotation that we put there on the Scandia Down Corporation, trademark help consumers to select goods. Okay, now to go into the indication of origin or source, this means that consumers usually connect the goods or services to their source. So, but this is only true if a trademark and the manufacturer are of the same entity and located in one locality. For instance, Indomie, owned by an Indonesian company, manufactured in Indonesia. So we can see the Indomie origin from Indonesia, and also the source is from Indonesia. But as business expands, okay, Indomie now is being manufactured in multiple countries, including the Saudi Arabia, because if we go for Hajj or Umrah, we can see that Indomie is very famous there. So as business expands, product are manufactured by licensee in multiple countries, but even though trademark manufactured by multiple licensees, trademark owners still retains control. Okay, and because of that, we can safely say that products manufactured by multiple licensees in multiple countries still retain the same quality, and in that sense, the quality is not compromised because it is directly manufactured and controlled by the trademark owner itself. So in all these issues, trademark protect both consumers and also trademark owners. Now, issue of trademark functions, origin and source is very important when we talk about 3D printing and also domain name. Because we will see later that in 3D printing and domain names, the source and quality is not there anymore. Now, looking at the types of trademark, trademark consists of sign. So sign can be any letter, word, name, signature, numeral, device, brand heading. So examples of trademark would be Toblerone for the shape of mark, color mark, the Adidas stripe would be a trademark for positioning, motion, sequence, and service mark, we have the JDT, Gojek, and also Celcom. Certification marks, halal. In Malaysia, we have SIRIM and MMC. MMC is for our telco. SIRIM is for certifying that a product is of a certain quality. Collective marks for accountants, patent agent, and business value association, and also well-known marks. But when we talk about 3D printing, the relevant trademark would be letter, word, and also shape of goods. Now, trademark basic a little bit again. It gives exclusive right to the owner to use the mark to market the mark for the mark for 10 years, and it can be renewed indefinitely. Okay, trademark owner can take legal actions against unauthorized use of their registered trademark. And again, the principle of territoriality, we have mentioned this briefly earlier, that trademark must be registered in every country that a business wants to go to, because protection is only territorial. And even though a business go under the Madrid system, the trademark still required to be protected in each and every country. Specificity means that a same trademark can be owned by multiple owner if they are for different goods or services. But the most important thing, trademark must be distinctive, not generic or descriptive. Okay, just some quick example. Is this Maggi or instant noodle? In Malaysia, I'm not sure about in Indonesia. In Malaysia, we always say Maggi to refer to everything. It doesn't matter whether it's Indomie or Chef or Samyang or Hami, it's all Maggi to us. But in fact, trademark students or trademark agents would need to know that Maggi is a trademark, but it is not a generic term. It should not be used generically to describe instant noodles. Okay, because we have to avoid a generic use of the product the trademark to describe the product, because if a trademark becomes generic, it can be cancelled from the registration. So you might like to look at the video by Kumar family, where he's a Malaysian living in the United States. So the family tested multiple instant noodle, and Kumar, being a Malaysian, of course, favors Maggi, but his wife, an American, prefers Samyang. Now, on the same point again, in Malaysia, Colgate refers to every toothpaste. It doesn't matter whether it is Sensodyne, Pepsodent, or Hajel. We call it always Colgate. And similarly, Pampers to refer to all type of disposable diapers. Doesn't matter whether it's Huggies or diapers. So this is something that should not be done. So students or any people who are relevant, familiar with trademark should not be using trademark to describe their product. Now, in Malaysia, there are two routes of protection. First of all is protection through registration. In Malaysia, we have the Trademark Act. So, trademark owner can register the act register the trademark under the act, and it can valid for 10 years. The other way of protection is through use. So, through use, this is a passing off system. Something that we inherit from the British legal system. So for passing off to be used, there is no need for the trademark to be registered. However, the cost of proving passing off could be high. Okay, passing off something we inherit from the British system. I think there is no equivalent protection in Indonesia, because in Indonesia, a trademark must be registered to get protection. Now, the important thing about passing off is that sometimes an owner do not register a mark, maybe by choice, okay, but the mark is being used in commerce, or maybe the mark does not fulfill the criteria under the law, but again, the mark is being used in commerce, or the mark has been applied for registration, but it is pending registration. So in all these three instances, in Malaysia and also in all Commonwealth countries, Singapore, Australia, New Zealand, Brunei, the trademark is protected under law of passing off. The two cases that I quoted here is a Singapore case. So the important thing about passing off is that there should be goodwill. Goodwill, it has to be local goodwill. Goodwill means the good name attached to the product. So in the case of future enterprise, a goodwill that the plaintiff have in Russia for the coffee trademark is not sufficient to establish goodwill in Singapore. And also in the case of athletic food, is a UK case. They could not be goodwill of a foreign. They could not be a goodwill of a foreign plaintiff. Now we move on to trademark and 3D printing. Okay, 3D printing or additive manufacturing is something that is not new. It has been in existence for the past 30 years, but it becomes an issue under trademark law when the patent for 3D printing expired, and now 3D printing becomes it can also be personal 3D printing. So initially 3D printing is used by industries, and it is a manufacturing process that is different from traditional production, because if we want to make a product, if say a casing of a computer casing or a vase, so they should be molding, casting, fabricating, and machining of the material from raw objects. So if you want to make a vase from clay, so from clay, then we have to do a lot of molding and casting. But with 3D printing, the vase can be printed using a 3D printer. So with 3D printing, a user can create, modify, or replicate objects by printing them from files using a 3D printer. So in fact, issue of 3D printing is not novel only in trademark. Patent, copyright, design also relevant, but for our purpose, we will only talk about trademark only. Okay, Stephen Bestol, according to him, 3D printing transform product, the way products are produced, distributed, and consumed. And with this printing, objects can be built by creating layers of material on top of each other. And Santoso, an Indonesian author, said that 3D printing fosters creativity, self-expression, and also innovation, where it enables consumers to co-create products Otherwise, it can only be mass produced. So the issue of mass produced is also important here because issues of trademark infringement, you will see that normally there are a lot of trademark counterfeiting goods available, okay, but most of the time this trademark counterfeiting goods has to be mass produced. But with 3D printing, it can be customized and produced in our own home. Now, two types of 3D printing. Industrial 3D printing, this is the most common one. Industrial sector would be construction, industrial design, automotive, aviation, aerospace, military, and also for testing industry. But for our purpose, we are concerned about the personal 3D printing because a home user with a 3D printing can print any product or any goods that they have, that they want, if they have a 3D files. So a 3D file can be available on the net for free. If you are interested, you can just Google 3D marketplaces. So you will find at least there's a lot. There's more than 30 marketplaces offering 3D printing services. So in these 3D printing marketplaces, a user can download some digital files in CAD file or STL file, and some marketplace also allow a user to modify, okay, sometimes for free or sometimes you have to pay. Some 3D marketplaces also offer printing services where you can ask them to print for you and pay a certain amount of money. So in other words, if previously, if someone wants to buy a counterfeit, but please don't do that, want to buy a counterfeit product, counterfeit shoes, counterfeit handbag, counterfeit earring, counterfeit, they will have to go to a store or buy. But now a user can print that in their own home. Okay. Now we have looked at the definition of sign before. So for 3D printing, the relevant trademark or sign for 3D printing would be word mark, logo, and also shape. So word mark, when a user print a product, sometimes a trademark is attached to product. So if that is if a product is being printed, and on the product there's a word trademark. For instance, if a user printed a Mercedes-Benz key holder, okay, in the key holder the Merc logo is printed there, so potentially there's a trademark infringement there. And again, if a user print a handphone casing, and in the casing there's a logo there's an Apple logo there, okay, so potentially that could also be a trademark infringement. And shape of goods, if we print a perfume bottle, SK Giorgio Armani bottle, so now bear in mind that now bottles of perfume bottle, Coca-Cola bottle, now trademark, patented as trademark. So if a user print the bottle, okay, that could also be potentially infringing. Now, but the issue is that would a trademark owner go and take actions against personal 3D printer at home? So this is just some of the examples that of 3D printing. Okay, the first one is a lizard pendant and a diamond ring. Okay, you can get that from Turbo Squid page. And interestingly, 3D printing also allow us to print food. I'm not sure whether we would want to eat food that is being 3D printed. Bicycle accessories can also be 3D printed. Casing of handphone, okay, iPhone can be 3D printed. You can see that in the yellow 3D case in the casing, there's an Apple logo there. Ring And I've also found two 3D objects being printed relevant to the COVID, which is a door handle and also a face shield. These are all from materialize.com. So if you're interested, you can go to this web pages and see the many things that can be 3D printed. Some of them are offered for free. Some of them we have to pay a certain amount of money to get the CAD files. But before we can do that, you need to buy a 3D printer first. Now, 3D printing in a way challenges two concepts of trademark, okay, which is functions and also used in trade. Functions of trademark, we have seen earlier that there are two functions, origin and also quality function, and also trademark must be used in trade. Okay, a trademark that is not used in trade, there would not be any trademark infringement. Now, when the trademark law was being developed many years ago, the law does not anticipate that goods are being printed by users themselves at home. So the law when the law was formulated, the law was concerned about counterfeiting goods among business entities themselves. So the law have not anticipated that in future home users would be printing goods that have trademark in their own home. Now, we have seen that functions of trademark are two, origin and also quality. Looking at the example of an Adidas shoes, yeah. Adidas shoes manufactured by licensees, there is no difference in quality of the products. Okay, the shoes that are being manufactured in 5 countries, in 500 countries, in over 55 countries, the quality are the same. So consumers can be confident that any Adidas shoes that you buy in any country, in any shop, regardless of where the shoes are being manufactured, the quality are the same. So in other words, for Adidas shoes, okay, qualities of the shoes are guaranteed, even though the origin of the shoes are not from the main manufacturer, but the origin could be from the licensee in multiple countries. Now, in 3D printing, okay, trademark can no longer be viewed as indicators of quality or origin, because when a user print, for instance, an Adidas shoes, yes, the origin is no longer from Adidas company, but the origin is now from the marketplaces that offer the CAD file. Okay, and instead of the trademark in 3D printing becoming the quality or source of the brand, it now merely becomes a consumer's familiarity with a brand identity. So in other words, with 3D printing, the functions of trademark of origin, source and quality is no longer relevant. 3D printing changes the functions of trademark. Because now with the 3D printing, consumers become the manufacturer of their own trademark products. Trademark products like Adidas or Mercedes kitchen holder are not being produced by manufacturer or their licensee, but instead with 3D printing, using the CAD file or SLT file from any 3D marketplaces, user can print their own product at home. And interestingly or not, with 3D printing, a user can also modify or alter or change anything in the design. So in that sense, a trademark ceases to function as badge of origin. And with 3D printing, consumer can no longer rely on trademark to make inferences of quality or origin. For instance, if we again look at the example of the Adidas shoes, so if the home user with a 3D printer changes the strap from 3 to become 4, or make it the stripes to be slightly smaller or with a different color. So it could also be that it can also be lower or tarnishes the quality of the trademark. But I have not found any court cases regarding trademark use of 3D printing. So perhaps this argument becomes merely academic at the moment. Okay, the other point that we would like to raise is that 3D printing allows counterfeiting of trademark goods at home. Okay, user can customize the product and make one-off production of any counterfeit goods. Okay, as we have said earlier, counterfeiting are mass-produced. Now, the preferred view is that 3D printing of a trademark goods by a home user may not amount to trademark infringement because there's no element of use in trade. Okay, because it is just for personal use, domestic use, and we are all aware about trademark legislation. Trademark law all requires that the trademark infringement must involve use in the course of trade. So in 3D printing, there is no trade involved unless, of course, if the home user suddenly later offer the 3D printing goods to be offered for sale, then probably there would be element of use in trade. And again, policing and enforcing trademark infringement against home users could be very difficult. There is something that maybe the trademark owners would not want to do. Okay, I think that is it about trademark and 3D printing. Moving on a bit to domain names and trademark. Okay, another area of concern about the digitization of the business is that the conflict between domain name and trademark. Okay, domain name we are very familiar. Apple.com, Samsung.com, Mercedes.com, those are all domain names. Okay, and businesses, of course, they want their online store to use a domain name that corresponds to their business name or trademarks. And domain name is a first come first serve basis. So initially in late 1990s, 1997 and 98, the issue of domain name became the cyber squatting issues of domain name was very prevalent. And businesses are very concerned because sometimes their competitor or any person not related to their trademark or business names manage to register their domain name first. Microsoft will be registered by someone that is not Microsoft owner. So that one of the earliest cases on domain name and trademarks. Issues about domain name and trademark disputes, of course, because it involves trademark, the main response would be to go under Trademark Act. But as the cases in the UK have shown us that it is difficult to prove use in the course of trade for domain names, because initially, first of all, domain names are not like trademark, but domain name only functions as trademark. Should have this slide first. Okay, domain name functions of trademark. And because domain names become information business identifier, so in that sense, domain name functions like trademark, even though domain names are not trademark. Okay. So in that sense, the WIPO in 1999, the US they pressured WIPO to have a recommendation on dispute between domain name and trademarks, and because of that, WIPO come up with the UDRP. This is a UDRP. UDRP is a form of ODR whereby all disputes involving domain name and trademark can be settled using a UDRP procedure. So now issues of domain name and trademark, there is no need to go into court. Okay, because as we've seen in the UK case of 1 in a million case, okay, it is difficult to prove use in commerce, and also in this case, the plaintiff did not the plaintiff did not go for Trademark Act, but instead go into passing off action. But in the US is a different issue, different case, because US have adopted the ICANN policy into their law. They call it the Anti-Cybersecurity Consumer Protection Act. So in the US, cases of domain name disputes can still go to court under the ACPA legislation. Okay, more about the UDRP. So disputes about domain name and trademark can now be settled using any of these 6 UDRP provider, the ACDR, the ADRC, ADRC, CI in Canada, the Czech, NAF, and also WIPO. Okay, and finally, in Indonesia, you have the Pandi. Malaysia, we have the MyDRP at KL at AIAC. Okay, sorry, tongue twisted a bit. Okay, I suppose that's all for me. So the take-home point is that new technologies such as internet and 3D printing continue to challenge trademark principles. Okay, 3D printing issues and trademark are not tested yet, so they are merely academic. But issues of domain name and trademark, we have seen from the case of the 1 in a million that traditional trademark law is not suitable to deal with issues of domain name and trademark because of the difficulty of proving use in commerce. Therefore, UDRP, which is a form of ODR, is now become mandatory for all domain name registrants. I suppose that's all from me, Mr. Pulong. Back to you.
Okay, thank you very much, Prof. Sinatul, for a very comprehensive presentation, and also the very, very strictly on that field. I mean, like in intellectual property law, especially in the domain name and also the trademark. So actually now we're going to question and answer sessions. Is there any question? Please raise your hand. Since the chat is no question, I think everybody in here or participants can directly ask to Prof. Sinatul directly in orally. So maybe you can raise your hand. So I will like manage you to just deliver the question. Is there any question? Yes, please. I think still waiting, Prof, because I mean, like the presentation is really, really comprehensively. So that's why that they still have thinking about the questions. Okay. Is there any question? Or maybe I should nominate you.
Hello.
Okay, Meg from the University of Canberra. May you take the floor. Just proceed, Meg. Please.
Hi, I'm Meg from the University of Canberra. You said earlier that trademark is territorial. Does that mean that a trademark, that it's not registered in a specific country, a random person could come in and trademark it in that country and not face repercussions, or are there regulations to prevent stuff like that?
All right, thank you, Meg, for the beautiful question. So Australia is a member, follow the common British common law system. So even though trademark are territorial, which means that a trademark, a Malaysian trademark will have to register in Australia to be protected. But even though it is not protected, registered in Australia, okay, principle of passing off would still be relevant. So in the sense that as long as business, for instance, what example should I use? If a Malaysian business, okay, have a trademark in Malaysia, okay, for instance, our famous trademark would be, I can't remember our famous trademark.
Qantas maybe.
Qantas, no, it's an Australian trademark. Okay, yeah. Okay, let's use Petronas. Assuming Petronas, yeah, everybody knows Petronas. So assuming that Petronas is a Malaysian trademark, okay, registered in Malaysia, but not registered yet in Australia. Okay, so in that sense, fundamentally, the Petronas trademark is not protected in Australia, which means that any Australian can register a similar trademark of Petronas for their goods in Australia. Okay. However, if Petronas can prove that Petronas have goodwill in Australia, okay, either by way of having a business in Australia but have not yet registered their trademark there, then Petronas can use the principle of passing off if there is any other person in Australia that uses a similar trademark. There are many cases involving this regarding Malaysia and in Singapore. In one case regarding the Minlon and Minlon trademark, a trademark in Malaysia in a Singaporean owner a business in Singapore have business in Malaysia, but the trademark is not being registered. But because the Singaporean businesses could prove that they have business in Malaysia, so the Malaysian court accepted evidence of reputation and business goodwill in Malaysia and allow the Australian trademark to protect the Australian trademark in Malaysia under the law of passing off. Does that answer the question, Mac, or you need further clarification?
Okay, Mac, maybe you want to have to make the point of clarification or the point of confirmation. You may proceed also. Or is it enough for you, the answer from the Prosinatu, Mike?
It was good, thank you.
Thank you. Okay, it's pretty clear. Okay, so, sorry, is there any question from the participant? You can ask directly. Okay, maybe since there's so many have university in here to join this summer course and from the 8 countries, so maybe I will give nominate or asking for the representative of the Flinders University maybe to deliver the question. Is there any participant from the Flinders University of Australia here? Please ask the question.
Or you could also give your perception regarding the protection in your own country. Is it similar?
Yes, Doc. Yes, Prof.
Or maybe the participant can respond by looking whether they have a similar issues in their own country.
Yeah, I think it's a good idea. Is there any from the Flinders maybe? Hello? I saw that they have representative Flinders University in here. Okay, maybe still waiting. Okay, maybe in your university, Prof, from the National University of Malaysia. So I asking the representative of the National University of Malaysia to deliver the question because so many participants from UKM this year, as usual. Okay, now maybe I nominate is there any before I pointing someone to deliver the
Can I also ask, has anybody any experience of 3D printing something?
No.
I'm so sorry for technical problem because my internet is down now. Okay, now I saw that somebody raised hand in here is from the Andi Sendra. Sorry, from Andi Sendra. Okay, for the Mr. Andi Sendra from Universitas Diponegoro, you might proceed.
Okay, good morning, Prof. Zinatul. My name is Andi Chandra. I'm from University of Diponegoro. I want to ask a question. Speaking of trademark, there are a lot of sign of trademark that you mentioned before on your presentation. But how about the regulation for fake brand, like imitating some product of a brand, like a famous brand? Is that also violated the intellectual property or what? Thank you.
Thank you for the question, Andy. So Andy asked about the imitation of famous brand. You right, Bruno?
Yes.
Yes.
Yeah, correctly.
Famous brand is famous trademark, well-known trademark is a trademark. Okay, in fact, famous trademark enjoys a higher protection than any other ordinary trademark. So remember, we talked about principle of specificity. Specificity means that a trademark is specific to a particular goods or services. Okay, so in that sense, there could be one trademark owned by two different entities in one similar country if the trademark of for two different goods or services. Say trademark A can be for product A, trademark B can be for same trademark but for different goods. Okay, there are many examples like that. However, for well-known trademark like KFC, McDonald's, okay, the principle of specificity is not relevant. So in the sense that even though McDonald's only go for fast food, so McDonald's enjoys the trademark protection in all sector of product or services, which means that nobody in the whole world can use a trademark resembling the word McDonald, okay, because the McDonald trademark is famous. So the law that can go is of course the trademark law. However, interestingly, at least there are two cases. Malaysia, we have the McDonald McCurry. Okay, in McDonald McCurry, the Malaysian court was very brave to say that the McCurry trademark does not infringe McDonald trademark. So you know what McDonald is. Now McCurry is an Indian restaurant selling Indian food in banana leaves. So McDonald in that instance sued McCurry for infringing their trademark. So initially it seems that McDonald could win because McDonald is a well-known trademark. Okay, so in that sense, the protection of well-known trademark is over and above any other trademark. However, interestingly, the Malaysian court, as I said earlier, was very brave to say that in the case of McCurry, an Indian restaurant selling banana leaf curry does not infringe the McDonald trademark because the product and the goods and the customers are different. Okay, people that go to McDonald's do not go to McCurry, maybe not so. And also the get up of the businesses are different. You know how McDonald's operators dress. And if you have been to Malaysia, then you know how Mamak store, they dress up. So it's two different things. And from our last session with Yupunagoro lecture last year, Mr. Pulong also mentioned that in Indonesia, even IKEA failed. IKEA is a famous trademark, yeah, as you know. But in Indonesia, IKEA failed to sue another Indonesian business for the same trademark of IKEA for furniture. So again, like even though a well-known trademark enjoy a higher protection than any other trademark, okay. But I believe that in some countries, our court are very brave to break the chain. Okay, that's my answer to that.
Okay, thank you, Prof. Sinatul. So now I come back to Andy. Is there enough the questions, the answer from Prof. Sinatul, or maybe you want to address the clarification or point of confirmation, Andy?
Okay. How about I have a following question.
Yes. Can you turn on the camera first?
Sorry, no, we'll prepare. Okay.
Okay. Yeah. How beautiful you are, so we can see your face. Yeah.
You look beautiful, Andy.
Yeah.
Okay. How about if the cases about the fake brand? I mean, like there's a lot of Louis Vuitton, like Gucci, but
Chanel, yeah.
Yes, like that. They really, have the same product, but the quality is different. But how about that cases about the fake brand?
Oh, interesting issue, but don't really have an answer to that actually. Okay, a simple answer to that would be counterfeiting product is a trademark infringement. There's no doubt, because a trademark owner enjoys the exclusive right to use the trademark in commerce for 10 years. So any other person that manufactures offer for sale, okay, actually sells a product that resembles or assembles a brand in identical brand or similar brand, okay. If you have an ODM products, okay, there is an infringement of trademark, but the issue is whether the trademark owner wants to take actions or not. Okay, they can take actions directly against the seller or the manufacturer, or in Malaysia at least, and also in Australia, I believe the same position. There's also a criminal action at the trademark, whereby we have the TDA, Trade Description Order, where we can report that to our relevant ministry, and the ministry will make a raid and confiscate all the products. But the difference there is that when a raid is made by the ministry, the trademark owner will not get any damages. But if a trademark owner go a civil action and sue the manufacturer personally in a civil action, then they can get damages for their infringing goods. Okay, is that okay, Andy?
Is it pretty clear, Andy?
It's pretty clear.
Okay, thank you very much. Yeah.
Yeah.
Now, Professor, if you look in the chat or pay attention on the chat, we still have a 3 questions from Taylor University, from UKM, and also from our university, from Dennis UKM also. But before that, I will asking them, to asking directly. So maybe I giving the floor first from the Dennis UKM. Please turn on the camera and you can directly answer the question. You can directly deliver your question. Is there any Dennis here? Dennis, hello? Dennis? Okay, so Dennis, hello?
Yeah.
Yeah, please deliver your question.
Greeting, Prof. Michael. I am Danish from UKM. I want to ask, does 3D file can be protected, especially when the content of it considered as patent or trademark that were registered? Thank you.
Okay, a 3D file is a copyright subject matter. So it is protected as a copyright subject matter. So, but if you're familiar with the 3D printing, most 3D enthusiasts, they will offer their 3D files for free. So it becomes open source. So initially 3D file is a copyright, which falls under is an IP, okay, not patent or trademark. A CAD file is a copyright subject matter. Okay. However, most 3D printers, if you go into marketplaces, they offer their 3D file for free. So they waive their copyright. So it becomes open access. So it becomes open access. So when the user download the CAD file and print from the CAD file, so it does not amount to any copyright infringement. Okay, trademark infringement may occur if in the 3D file, the product that is printed using the CAD file, there is a logo there, a logo that belongs to a particular trademark. If it's just a vase without no logo, then that's fine. But if there's a vase but there's a Gucci trademark on that, then there's an issue. Okay, is that okay, Danish?
Yes. Thank you.
Okay, thank you for the answer, Prof. Now we're going for the second question from Shahwan. Shahwan from UKM also. Please, Shahwan, turn off your microphone and deliver your question directly. Hello, Shahwan. Or I read your question. Okay, so Prof, maybe I will read for you. They have question from the Shahwan from the National University of Malaysia. The answer, I'm not sure that some of Malaysia do not know about the step that they need to take if the logo has been used. Maybe you can explain on what are the reasonable steps to be taken if these things happen to them. I think it's like the claimant by Shahwan.
Okay, let's take Petronas again. Petronas is a logo. Okay, so first of all, it has to be registered, and you have to use it in commerce, and you have to also promote it and make sure that the trademark is not being used generically. So for instance, we have talked earlier about the Colgate or Maggie being generic. So if you think that there's anybody who is infringing your trademark, okay, then you can just take action. The action would be just legal actions lah. Threat, disease and disease letter, threat letter, or complaint to KPD and KK for the KPD and KK to make a rate of your product. But first, before that, make sure that your product is registered first. The trademark is being registered at MyPo. Otherwise, you wouldn't. Then you cannot take action if your trademark is not registered. Shazwan, you better take my class next semester, yeah.
Yeah, I think it's that good idea. Yeah. So you can maybe directly asking person to Prof. Zinatul, yeah, Sawan. And I'm very enjoy the class with Prof. Zinatul actually. Okay, Prof. Actually, the next question, yeah, maybe I will read because they have unstable connected from Miss Nur Amal Shahira. So the next question is from Sahira from the Taylor University in regard or about following Andy's question. It was smaller company or individual copying from the bigger company, but what if it was the other way around? Recently, a fast fashion retailer, Sein, based in China, has been accused of stealing design from the smaller company. Can this smaller company take the actions? Back to you, Prof. Yeah.
Thank you, Shaira. I'm not familiar with the case with the Shen issue, but of course, anybody with registered IP, it doesn't matter whether it's design, trademark, patent, or copyright. Okay, make sure that you have your IP registered first. Registered meaning that you have to go to your IP office. Okay, MyPo here in Malaysia or Jan Haki in Indonesia. Make sure that you have your registered certificate. Okay, and if it is registered, then if you believe that your design or your trademark or your patent has been infringed by anybody, it doesn't matter whether it's big or small company, of course you can take actions. But taking an action is not that easy lah. You have to go and appoint a lawyer, and that's why not lah.
Okay. Is there any follow-up maybe from the Sahira, from the answer from Prof. Zinatul, or is pretty clear? Hello, Sahira. Okay, maybe I think that is pretty clear. Okay. Now we're moving from the last question, Prof, from Elisa Julie. Yeah. So Elisa, you want to directly asking directly, or I read your question? Or maybe I'm giving the chance first to for Elisa to ask directly. Come on, Elisa, you might proceed. Active your microphone, please.
Okay, good morning, sir, and good morning, staff. I have a question regarding about the regulation in Malaysia about trademark claims. Because like in Indonesia, there are several food outlet brands that are fighting over their restaurant logos, which are considered plagiarized by other restaurants. How the regulation in Malaysia about this problem solved? Thank you.
Back to infringing again, Prof. Yeah, so maybe back to the Prof. Zinatul.
Okay, thank you, Eliza. Okay, I think the issue is not common. It's not uncommon here in Malaysia. Okay, we have many businesses using a similar trademark, and sometimes they are very confusing. So it happens everywhere actually. So again, what's the regulation relevant would be again the Trademark Act. Okay, Trademark Act meaning that if you have a business, you have a trademark, then you have to register your trademark first with the Jan Haki, and you have to use it in commerce, and make sure that the trademark that you have is distinctive. Distinctive meaning that it is not generic. For instance, if you have a trademark, if you have a business selling ayam penyet, do not have a trademark called ayam penyet unless the ayam penyet, the word trademark ayam penyet come with something else. It comes with a chicken there, or there's something that does not resemble to nasi ayam penyet. It cannot be generic. Okay, that's why you can see that many of these strong trademarks in the world, like Kodak, for instance, or ESO, it does not means anything. Okay, ESO using for oil. It does not describe the product. Yeah, you cannot use a trademark chair to attach to a chair, because chair is generic to describe chair. Okay, you can see many examples here. For instance, we like to use animals to become our trademark. Camel is an animal, but we use camel for our clothing, our watches, yeah. Crocodile, snail, so many examples of animals. So you make sure that your trademark is distinctive. Distinctive means that when people see your trademark, they know it's yours. For instance, our Petronas trademark logo in Malaysia is just an oil drop in turquoise color. In Pertamina, the trademark is the word P with several colors, yeah, Mr. Pulong?
Yeah.
It's distinctive. Yeah. So in that sense, make sure your trademark is distinctive. Only then you can prohibit other people from using a similar trademark. But if you are selling ayam penyet, but you having the trademark ayam penyet spelling AYAM and penyet, maybe in red color, yeah, just red color, and you put it there as ayam penyet, you cannot prohibit another seller of ayam penyet selling a similar dish using the same trademark. Using ayam penyet also as a trademark because that is not distinctive. Okay, does that does that answer the question? Maybe Pulong would like to add to that, please, Mr. Pulong. You are the expert.
No, actually, I think the Prof. Zinatul is already pretty clear deliver the point, Prof. So I don't need to add. I'm just moderator in here. The highlight is yours. Okay, thank you. Is it very clear, Eliza? Hello.
Yes, sir. Thank you.
Okay.
Prof.
Now we still have two questions, Prof. The question is still again. So they have question also from Siti Nurjana. So before I read the question, maybe I give opportunity to Miss Jana to deliver question directly. Maybe turn on your microphone, please.
Okay, Assalamualaikum, Prof.
Salam.
Okay, my name is Jana. I'm from UKM. So I would like to ask, what if we make a 3D painting or trademark without having the trademark is already patent? Because sometimes we have no knowledge about the patent trademark, like especially the unpopular one.
Jana, a simple answer would be ignorantia juris non accusat.
Okay, sorry.
Which
Okay,
means you cannot claim that you are not aware of a particular law. Yeah. So, and also as students of law, you should be very vigilant, not to, if you download a file from the internet, okay, that allows you to 3D print something, I think it would be best if you just make a search, just Google search and see whether the logo that you find on the 3D file, does that have a trademark and whether the trademark is valid or not, is protected or not. Yeah.
Okay, Paul, thank you.
Okay.
Okay, I would like to respond to a question by
Just one.
By Tan Ejin, I think.
Yeah, Tan Ejin. Yes, they have question from the Tan Ejin. So, Mr. Tan Ejin, you would like to deliver the questions? Or
yes, hi, Professor. So, following your response to Shahira's question, I'm just curious if there are any legal protections for small business owners or like artists who can't afford trademark protection.
Okay, you're from Malaysia, I suppose? All right. Okay, the good news is that MyPo if you go to MyPo website, you would know that MyPo actually offers a lot of incentive for SMEs and also for youngsters. So in fact, youngsters can have their trademark. I'm not sure whether it's free or not, but it's a very reduced price. And they also offer several grants if youngsters wants to patent their inventions. So I suppose MyPo, if you go to their website, they can give discounts. I shouldn't be saying that. There are many. They give many. They help SMEs. Okay, and in fact, trademark are not expensive. Maybe about 700 ringgit only for registration. It's not expensive. Yeah, but patent are expensive.
All right. Okay. Thank you, Prof.
okay.
Thank you.
Thank you, Tan. Okay. Now, Prof, they have still following question by the same participant that asked before. Yeah. So I'll giving again the floor to Danis. Yeah, to following up the question, please, Danis.
Good morning, Prof. I hope my question will not be confusing. Okay, so I want to ask, as you have mentioned, 3D printing has made trademark can no longer viewed as indicator of quality or origin. Does this will create new possibility for company to mitigate their ability on the quality side for their original product, especially on this time of emergence of online shopping, second-hand item resale, and DIY 3D printing disguised as genuine? Thank you.
Interesting question, Danish. So for instance, let's say Mr. Pulong 3D printing, sorry to use your example, Mr. Pulong.
Yeah.
For instance, Mr. Pulong 3D printing Adidas shoes, but the Adidas shoes is of different stripes. Okay, and maybe it's not so good. Maybe you modified the design, so you add a little bit, little bit groovy there, groovy here. So because of that, it no longer resemble an original Adidas shoes. Okay, so does that allow Adidas to say that they are not they can mitigate the liability for default of the product? I suppose yes, but it's difficult for Adidas to prove that. What do you think, Mr. Pulong, about this?
Yes, sorry, Prof.
What do you think about this?
Actually, I also don't get it the point, Prof.
Danish, can you elaborate the fact that you the 3D shopping and DIY discussed as genuine?
Okay, I think this might be confusing, but okay, I'll try. So example, actually, let's say, there are case of the original product become much like it's the original product, but it's have like default on the quality of it. Okay, and then but then the buyer is buying from internet shopping, online shopping. So the online shopping, sometimes we have this kind of group of people who sell the resale item, original reselling item, or they also group of people who DIY 3D this DIY 3D printing. This who they describing as genuine, but we never know the actuality of every seller. Is it just resell the true genuine thing or not, right? So on this platform, the genuineness is quite hard to tell, and then and hard to prove, especially in the court. So I want to ask, when is the product in that were dispute actually were original product, but then the originality is disputed, right? So when in the court, how does the court does the company of contohnya example Adidas, does this create the opportunity for them to create okay, stop, this is not ours, this is not our product, this different from our product. That I want to ask, does the company have like opportunity to mitigate their possibility on the quality of it?
All right, okay.
Okay.
I'll try to answer. I think okay, put it into a scenario, yeah. I buy an Adidas shoes from an online shopping, okay, from Shopee, okay, from a store that Danish is the owner of the store. So Danish actually is a reseller of Adidas. However, instead of you buy the product from Adidas Indonesia or Adidas Malaysia, but you 3D print the shoes. Okay, when you 3D print the shoes, somehow or other, instead of the 3D print the shoes become perfect quality of the original shoes, but your 3D printing of the shoes now is quite default, and there's some messy somewhere here and there. Now, when I buy the shoes, I was expecting that the shoes to be like Adidas shoes, even though I know that it is 3D printed. Now, who do I sue? Do I sue you or do I sue Adidas?
Adidas.
Okay, let's say I sue Adidas. So if I sue Adidas, on the assumption that Adidas is the manufacturer or the authorizes you to 3D print their shoes, okay, can Adidas now say that this is not their shoes because of the default? The answer would be yes. They can disclaim that. And how do they do that? Of course, they would have to give they will have to take expert evidences, expert witness to say that, to show how their shoes are being made, to show who are their licensed manufacturers, and to show that you, a reseller on Shopee, is not their authorized reseller. Is that answers your question, Andy? Andy?
No. Dennis.
Dennis, does that answer the question, Dennis?
Yes, but example, if the issue, if the, how to say this, if there was no particular, very default, like how to say that, not a much something wrong, no flaw on that product. So how to prove is very difficult, right?
Yes.
Yes. Yeah. If on that note, if there was no flaw on the product, how court have to actually prove it, and then does the company actually have the possibility to mitigate on that note?
It was both ways actually. So the person who, the plaintiff who says that the product, both parties again, what year are you now? Second or third year?
Just finished my first year.
Oh, first year. All right. When you go to your final year, you will know that you will be taking a lot of evidence, whereby in a lot of evidence, both parties, plaintiff and defendant, will have to bring their own expert witnesses. Expert witnesses meaning that the Adidas will have to show, like I said earlier, give proof how to their manufacturing process, their licenses, and the other party will again have to give proof that the other way around lah. So it works both ways in the sense that Adidas can mitigate their claim, and the other party can also give evidence to say that it is indeed Adidas shoes.
Or maybe in addition, the expert witness will be a presentation about the industrial design first, Prof. Sinatul. Industrial design first, because actually this is based on the industrial design of the Adidas. So that's why that maybe in the scientific evidences will be gained from there actually.
So the court will decide on the level of probabilities based on the expert evidence of both parties. Expert witness meaning the manufacturer, the scientist, MIPO,
and designer also, maybe the designer of the product.
The designer of the product.
Yes. I think this is like the I mean, like the cases from international moot court, I think. Like arbitration or something that way. I think it's my curiosities, and I think that maybe Danish want to eager to join in international moot court competition. That's why that they're asking the case in this chamber.
Yeah.
Okay, Danish. No, Prof, one question from your university again, from Shaswan maybe. Shaswan, you want to asking directly, or should I read your question?
Can you hear my voice?
Yeah.
Okay. Maybe I can ask for myself. Assalamualaikum, Prof. My name is Muhammad Shazwan from UKM, and I have one more question about. I think this is a bit like sensitive question, which is recently we already know that there's a person has been misused one university logo to promote hate among the citizens. So my question is this incident also can be filed under IP protection? And if there is any progress about this issue.
Okay, thank you, Shazwan. You're referring to University Qatar,
Yes, yes.
Okay, for those who are not, okay, for the benefit of our participant from another country, from Indonesia and also from Australia, UKM logo recently has been modified by one blogger, yeah, one IG by one Insta famous, to say UKM refer actually to Universiti Kebangsaan Universiti Kebangsaan Malaysia, but this guy, he changed UKM to become University Qatar Malaysia to refer to politicians who jump ship from one party to another party. Okay, so the issue, what can UKM do? Okay, can that be an issue of trademark infringement? The answer is yes, because a logo is a trademark. Okay, so if you want to know, Shazwan, UKM logo is a trademark. So UKM legal office can take actions against this guy. This guy is called Fahmi. Yeah, but I do not think UKM does that. And on the same note also, because the university logo is a trademark, so that also means that we cannot use a UKM logo without permission, in the sense that you cannot just 3D print UKM logo on your mark, because the mark is yours, but the logo belongs to UKM. Okay.
Is it pretty clear, Shashwan? Did this answer your question? Shashwan, hello? Shashwan? Okay, I think the internet
Yes.
is okay.
Yes, thank you for the explanation.
Yeah, thank you very much, Shashwan, for the question. Prof, maybe before moving in your closing statement, actually I have one question in regarding about the vaccine. Now, we know that we are facing pandemic and the vaccine is always to be developed well, yeah, to just like maybe against the pandemic itself. My question is very simple, Prof. If they have several the name from the trademark of the vaccine, should this vaccine is registered by one in the one country, in single register in one country, or should they can direct go to WIPO and using about the function of the Madrid Convention, and actually that they can register in multiple countries directly. So is it any problem if that we should register vaccine in certain condition like this in pandemic like this, Prof?
Good question. Questions coming from Pulong is never simple. It's always very challenging. Okay, I suppose the normal law applies in the sense that territoriality of trademark, which means that if Pfizer or Sinovac, Sinovac coming from China, then the China company, the Sinopharm, will have to register Sinovac in each and every country that they want to market the Sinovac vaccine. So as we have learned just now, they can go, Sinopharm can go to Madrid, okay? They can register at their Chinese IP office, and then using the Madrid system, designate means choose which country that they want to register their trademark. So in that way, they can bypass the Paris requirement of registering in each and every single country. So in other words, I hope that the vaccine company registered their trademark, or at least go under the Madrid system, because otherwise, if they fail to identify a single country that they want to register their trademark, so as the first question asked by Mac just now, it is perfectly okay for anybody in that country to register a similar trademark for their own product. Maybe I can give an example of a Malaysian case, as this is an old case whereby I cannot remember the name of the football company, but there's one case, tak boleh ingat lah, sorry Pulong, I can't remember the name of the trademark.
Okay. Yeah, thank you, Prof. Now we're going from the last session is closing statement. So maybe you can deliver a 5 minutes from the closing statement, Prof.
Oh, ada closing statement ya, Pulong. The closing
Yes.
statement can come from you lah. I'm very happy that there's so many questions today. So I'm very sorry if I did not explain properly, because actually in these times of pandemic, having this type of webinar is very challenging for academic as well, yeah.
Yes.
So I prefer giving lectures face to face, because you can see the faces and the expressions. So it's very challenging for us also. And I hope that everybody now can, after this lecture, can just go and Google 3D printing marketplaces and explore the possibilities, but do not 3D print anything that has trademark on it.
Okay.
Okay?
Yes.
Shazwan or Danis, jangan print ya. Anything or the UKM logo semua ya.
Okay. Thank you, Prof, for such very, like this a glorious time like this one. We talk about, talk of face to face, even in online. But actually, that this session, this occasion, is give beneficial knowledge from you to our participant today. And on behalf of our faculty, I say thank you very much. So this is not the end. We will see you again in the next summer course, Prof, because actually we still want to get in touch between not only in person, but you to you, our university, and also the National University of Malaysia. And also, and from the rest of the student or participant from National University of Malaysia, I strongly recommend to take Prof Sinatul class. Yes, don't forget for that. Okay.
Thank you for promo. Pulong actually is one of my best student.
No.
LLM. Well, he never failed to ask interesting question that I cannot answer. I have to pause and think.
No, Prof. I'm so proud of it. Thank you very much, Prof.
Thank you very much.
Yeah. Now we're moving back to the Danish. So for Danish, from the NC, time is yours.
All right, thank you so much, Mr. Pulong. And again, Prof. Zinatul, that was a very interesting class and then very fruitful for the discussion and question and answer for all of the participants. So before we move on to our next session, I would like for everyone to turn on your cameras because we are going to take pictures together. Okay. Okay, I guess we can start now. On my side, everyone. Oh, okay. You can turn on your camera for those who hasn't. All right. On my side, 3, 2, 1. Okay. Once more. Again on my side. 3, 2, 1. Okay. Thank you, everyone. Now, our first class session is finished, but there will be another session after our lunch break. And I hope you guys have enough time to relax yourself and fill up, because you guys will have to come back to this Zoom meeting in 1 p.m. local time Semarang, which is an hour-ish from now, an hour and 20 minutes-ish, I suppose. So I guess I'll see you guys soon after lunch. Bye.
Thank you, Prof. Sinatul.
Bye. Thank you, Pulong. Thank you, everyone. Bye-bye.
Yeah.
Thank you, Prof. Thank you, Prof.
Permission to leave.
Prof.
Okay.